Thank you all for being here. Please get a seat and we'll start. Thank you for attending this event of the Day of Dialogue. We have events scheduled throughout the day. In fact, there's another one scheduled at the present moment. Thank you for coming to this one. And if there are others that interest you, please attend other events today. If you're here for the Junk Science event, you're in the right room. My name is Phil Dalton. I am the director of Hofstra's Center for Civic Engagement. I am also a member of the Rhetoric and Public Advocacy faculty. One of our center's primary goals is to educate and foster dialogue about issues important to our campus, our community, and our world. And because we're all citizens of this world, we need to recognize that our decisions, whether we make them knowingly or by force of habit, shape the world for others. And being responsible citizens requires us to learn about the issues and to talk with and listen to one another, hear each other, and be in each other's presence, and consider fairly the thoughts of others. And that's why the Day of Dialogue exists. It was created 16 years ago by Dr. Cynthia Bogard. The Day of Dialogue is a day to celebrate the efforts of our students and our faculty who have worked together to prepare thoughtful and provocative discussions intended to increase our awareness of problems, consider solutions, and to entertain one another's ideas. And the events prepared for today will hopefully, in their own small way, contribute to a stronger community fabric. Many of today's events, whether directly or indirectly, focus on issues of relevance to the upcoming midterm election. The current event is no exception. Matters of science, criminal justice, and law enforcement are top concerns for many in the United States, especially in the wake of the George Floyd murder and responses to COVID by some in the United States that have discouraged faith in science-based health policy. More precisely, increased awareness of the false conviction phenomenon has leapt from the confines of the university into the public mind with growing attention in the press, in podcasts, and true crime documentaries. The present event was organized for us by Dr. Sharon Casimir of Anthropology. It is co-sponsored by the Departments of Anthropology, Sociology, Hofstra's Forensics Program, and Criminology Program. It's a pleasure to join together on this project with Dr. Casimir. On behalf of the Center for Civic Engagement, I thank you for your work. I thank our guest, Dr. Fabricant. I also like to acknowledge the Hofstra Cultural Center for their work organizing this day, the work of our center's graduate assistants, Joanna Lestor-Montez and Sarah Kemaradine, and the many Hofstra Fellows who helped organize and promote this and our many other events today. So now, please allow me to introduce Dr. Casimir.
Thanks, Phil. Welcome, everybody. Our guest today is Chris Fabricant, and he's the Innocence Project's Director of Strategic Litigation and one of the nation's leading experts on forensic sciences and the criminal justice system. Chris is featured in the Netflix documentary The Innocence Files, and his public commentary has been published in major media outlets. He's former public defender and a clinical law professor, and he's over 2 decades of experience ranging from litigating death penalty cases in the Deep South to misdemeanors in the South Bronx. Today he's going to talk to us about his experience on the Innocence Project and how that led him to write his book, Junk Science and the American Criminal Justice System, and we have copies for sale of the book in the back. Forensic scientists are idealized in American popular culture as infallible crime solvers, and I think we can all think of CSI, Bones, and other TV dramas that kind of make that case for us. Juries believe them as expert witnesses, and as Chris shows, innocent people are jailed and even executed as a result. In 2012, the Innocence Project began searching for prisoners convicted by junk science. 3 men convicted of capital murder became Chris Fabricant's clients. The book chronicles the fight to overturn their wrongful convictions and to end the use of science that destroyed their lives. The book weaves together courtroom battles from Mississippi to Texas to New York City, and it takes the reader on a journey into the heart of a broken, racist system and the role forensic science plays in maintaining the status quo. Junk science is a fascinating and well-researched insider's perspective on the American criminal justice system. With that, I welcome Chris Fabricant.
Thank you so much for coming out. I'm not a doctor, by the way, just in case you heard that, unless a JD still counts. I'm going to start with a reading from the book, because I think that if you got the idea that this is just about science, it would be kind of a dry topic. But this is a reading that shows kind of like the stories that are told in this book are very personal. It's about my clients in the Innocence Project. And yes, really, it's about the science that destroyed their lives. But I wanted to tell stories because I think that I know that's the way that humans learn, and that we can be moved by stories and at the same time learn a little bit about the use and misuse of science in our criminal legal system. So this is about, and it was really after this experience that I'm going to read to you about, that I decided to write this book. And so you're getting like kind of notes that are straight from my journal into the page here. Interstate 45 originates in the southeast corner of Texas near the Killing Fields, a 25-acre patch of dirt outside of League City where the bodies of at least 30 victims, nearly all young women thought to have been murdered by multiple serial killers, have been found since the 1970s. The highway runs a straight line north from League City through Houston before petering out in Dallas. The featureless terrain is so flat I could almost see Huntsville 65 miles away from my rental car as I headed north out of the Houston airport. An hour later, I passed the 70-foot-tall statue of Sam Houston on the outskirts of Huntsville. A white school bus with wrought iron mesh covering darkened windows passed in the southbound lane. The Texas Department of Criminal Justice's sky blue seal stamped on its side. Prisoners on the chain, handcuffed to each other for grinding cross-state bus rides on steel benches, heading from one cage to another. 58,000 prisoners endure roughly 22,000 trips or bus therapy across Texas every year, covering close to 5 million miles. Forgotten people going to hidden places. I pulled into the visitor's parking lot and stuck the file on the passenger seat in my shoulder bag. The inch-thick stack of paper represented everything I knew about Cheney's case. There were some pages of transcripts, Jim Hale's and Homer Campbell's testimony, a copy of the Appellate opinion, crime scene photos of the Sweeks' mutilated bodies, and dozens of photos of the U-shaped injury on John Sweeks' forearm. Julie Lesser met me under the 3-story red brick guard tower at the front gate. Razor-wired gates parted, and we walked along a sidewalk, cutting through a neatly trimmed lawn to the main entrance. At the guardhouse, a corrections officer scrutinized my New York State bar card before allowing me to sign in for a legal visit. Heavy steel doors slid closed behind us with a 1,000-year thud as Lesser and I walked the gray corridor toward a row of cubicles partitioned down the middle by thick plexiglass. Black phones were mounted on the right-hand sides of the walls. There, in the center booth, sat my first Innocence Project client. He'd been waiting a long time. During my time as a public defender in the South Bronx, I spent a lot of time visiting clients on Rikers Island, New York City's infamous island jail complex in the East River. My clients were mostly young men bursting with rage, fear, desperation, and yes, hope. In my earlier work as an appellate defender, my clients had already been convicted at trial and were just beginning to serve lengthy prison sentences, slowly emptied of hot emotions, nurturing hope for freedom in prison law libraries in upstate New York. Most of my clients, those thrumming with pent-up energy on Rikers, and those warehoused in century-old upstate prisons were deeply skeptical of public defenders. Trust was earned only through showing respect and fighting hard. Usually I lost. Often I would not see or hear from my clients again after a conviction. There was always another, more immediate crisis, another trial, another appeal, another arraignment shift. The wheel never stopped turning. There were thousands of individual people I represented, sometimes for a few minutes at arraignments, sometimes for a few years, but I had never visited anyone 25 years into a life sentence. My file also held Stephen Cheney's arrest photo, a color Polaroid from the day Detective Westfall pulled him off the construction site in Las Colinas. Deeply tanned from laboring under the Texas sun, Cheney wore a dusty white t-shirt that hugged his wiry frame, his chin pointed at the camera defiantly, exposing a prominent Adam's apple. His robust head of dirty blonde hair framed intense blue eyes. The coiled energy radiating from the photo is pure Rikers Island. That was not the man sitting on the opposite side of the grimy plexiglass. Cheney had been drained of color. His hair and his eyes had gone iron gray. Deep lines ran like rivers across his pale forehead and down the sides of his mouth. His dull white prison scrubs made him nearly invisible. Only the black, prison-issued Buddy Holly-style glasses stood out. I sat down on the steel stool in front of Cheney and picked up the phone. As he lifted his phone, Cheney bowed his head, seemingly collecting himself. When he looked back up, tears were streaming from his eyes and rushing through the lines the wind unit had carved into his face. "See," Lesser said to Cheney, "I told you he would come." None of the years I'd spent as a public defender had prepared me for this. I'd never walked into a client interview and been treated like a savior, like I was wearing a cape. For the deeply religious Cheney, Julie Lesser was a vehicle Jesus had sent him, and our meeting in Huntsville was further evidence of the greatness of God. Cheney had spent the last decade watching Innocence Project lawyers free his fellow prisoners. Here was his own. In that moment, I felt an awesome responsibility. Cheney had been a test case for me until then, an ideal vehicle for using the junk science writ to challenge the status quo. I did not think about whether he was guilty or innocent. It was simply a perfect case. But now I had a client who believed I could make prison doors open with the wave of a wand. It was terrifying. There was little I could tell Cheney about bite mark evidence that he didn't already know. At his elbow was a battered copy of Scientific Evidence, a comprehensive treatise on forensics edited by some of the most respected science and law scholars in the country. Cheney knew it better than I did. He knew about footwear evidence, presumptive blood tests, and polygraphs, the throw-in junk science used against him. Cheney knew subtle lies and liars. He knew waiting in line. But unlike me, he knew he was innocent. And unlike me, he had faith. I tried to temper expectations. There were a lot of bad facts and no more DNA to test, but Cheney never stopped smiling during the hour or so we spent together. He knew our meeting was a manifestation of his faith. "God bless you, Mr. Fabricant." I wasn't sure what to say. We pressed our hands together through the glass and I flew back to New York. So that was my first meeting with an Innocence Project client. And you think about some of the things that are mentioned in toward the end is the junk science that was used to convict him was bite mark evidence, polygraph evidence, a presumptive blood test on his sneakers that were said to show that there was blood on his sneakers, and a footwear impression evidence or bloody footprints leading away from the victims' bodies, and that was matched to Mr. Cheney's battered old Puma sneakers. And so when we first got into this, and when I was first tasked with really the idea of the Strategic Litigation Department was to find people like Mr. Cheney and see if we could free them without DNA evidence. Is that, can we prove innocence without DNA evidence? Can we overturn a conviction that's resting on junk science? And I want to be clear about what I mean by junk science, and I'm going to talk you through a little bit about how it got into court to begin with and what we're trying to do to eliminate it. And when I say junk science, what I mean is, and as I've defined it in the book, is subjective speculation masquerading as scientific evidence. It sounds like science. It's a lot of sciencey sounding language. And the language of science and textbooks are written about it, but there's no empirical basis for the opinions that are being offered. It's just subjective speculation. In other words, there's no valid scientific research to demonstrate that it's valid. There's no field research to demonstrate that it's reliable. Many, many forensic techniques have gotten into court without any scientific research, something that was just invented by police detectives to help solve crimes. And the other thing about junk science is that usually you can make it say whatever you need it to say. And when you have subjective techniques, and what I mean by subjective techniques are techniques that there's no measurement involved. The basis of almost all science, hard science, not social science, but even with social science, is measurement, right? You measure something in virtually every different type of science. And when you don't have measurements, if you're just eyeballing evidence, right? If you're thinking about like a fingerprint match, right? You're thinking about whether or not two fingerprints match. There isn't somebody taking measurements of fingerprints and measurements of latent prints found at crime scenes and measuring them up. People are just eyeballing the evidence. They're making a subjective judgment about whether these two things match. And so when you have subjectivity, like a lot of these junk science are completely subjective, then you have bias. And bias manifests in a lot of different ways, right? There's racial bias, implicit racial bias that we all have. If we're walking around on the planet, for better or for worse, primarily, is that we have implicit bias. But there's also a bias called cognitive bias or confirmation bias. And that's the mind tends to see what it expects to see. So, for an example, in forensics, let's talk about fingerprints. Now, I'm not saying that fingerprints are junk science, but you can take a very valid technique and make it pretty junky if you don't have high quality evidence and if you don't have shields against cognitive bias about information that isn't related to the fingerprint. So, very famously, in the folks remember a bombing in Madrid, Spain, a commuter train was bombed in Spain. 270 people plus were killed and many thousands were injured. So the FBI was investigating this and found the blast caps in a plastic bag that were used to blow up this train. And there was fingerprints on the blast caps. And they matched that fingerprint through a machine called APHIS that gives you candidates. And then the candidates are used, and a human being makes a decision whether or not one of these candidates was a possibility as a match or was the match. And they matched it to a mild-mannered lawyer named Brandon Mayfield in Portland. Brandon Mayfield had never left the country, didn't own a passport. But he happened to be Muslim, he happened to have married an Egyptian national, and he happened to have represented somebody that had once been convicted of providing material aid to a terrorist organization. So to the FBI, bing, 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 this is the guy, right? It solved this narrative. The narrative they were looking at was like an Islamic extremist, and they arrested him and held him incommunicado for almost a month. So fingerprints had not had high-profile misidentifications, but Brandon Mayfield kept insisting that this was not my fingerprint. The Spanish authorities disagreed with the FBI. The FBI brought in, and the court appointed additional experts to do another analysis of this fingerprint. And they concluded the same thing. It's Brandon Mayfield's match. He's the person who left this fingerprint. And it wasn't until the Spanish authorities identified the actual perpetrator, in all likelihood, the actual perpetrator is still at large, that the FBI admitted they were wrong and that they had falsely identified Brandon Mayfield as this terrorist. So this sent shockwaves through the forensic community. Shockwaves, right? Because fingerprints, unlike bite marks or some of the other techniques that I'll talk a little bit about, have been, even by people like me, reliable critics, as fairly reliable techniques. How could this have gone so wrong? So when they looked at it, they thought about, well, two of the problems, right? One was a low-quality print. And one of the things that you all probably believe that fingerprints are unique, I think that they probably are. That's not a scientifically validated fact. But what's more important in forensics is that we don't know how similar two prints are. And when you're talking about latent prints at crime scenes, you're not talking about the deliberately rolled prints that you're thinking about. You're talking about smudges at crime scene. And we don't have any objective threshold for how much information that we actually need before we can make a match and try to exclude everybody else on the planet from having the possibility of also matching that. So we don't have that information. And then you have the added problem of contextual information, like the fact that Brandon Mayfield was Muslim or that he had once represented somebody accused of terrorism, as information that has nothing to do with whether or not these two things match, right? You don't need that information to make that decision. So E.T.L. Dror, in the aftermath of this, Dr. Dror is a cognitive neuroscientist in the UK, did a really, really important experiment that's since been replicated in other areas. But what he did is that he took a number of highly qualified latent fingerprint experts, board certified, all the rest, right, one from the FBI, and he gave them casework. And what was clever is that he didn't tell these experts that it was their own prior casework. So in other words, they had already analyzed this evidence and come to conclusions, match, no match, inconclusive, whatever. And the only thing they changed, though, was the contextual information that was included in the case file. So so-and-so confessed, or there was an eyewitness, or there was this other evidence that would tend to point one way or the other. 3/5 of them, 3/5, changed their mind. Nothing had changed about the latent prints at all. The only thing that had changed was the information, the irrelevant information that had been used and that was part of the case file, and that was enough to change their minds. And that's been replicated in forensic anthropology and DNA analysis, which also has a measure of subjectivity, particularly some of the earlier, including current uses of technology, of that technology. So the FBI, to their credit, took measures to blind their experts, their fingerprint experts, of irrelevant case information as a result of this debacle. That's the only agency in the country and the only technique in the country that actually does that. Still today, this type of irrelevant information is used and influencing forensic experts. Somebody in court right now is testifying, and they have all the case facts that they didn't need before making that. And what's compelling is that when I litigate cases in post-conviction, fingerprint cases or other types of cases, what I will often do is blind an expert from all the case facts, tell them nothing about it, and ask them for an objective, independent evaluation of this evidence that was used to convict my client. And the 3 times that I've done that, twice, the latent fingerprint expert has come back with a different conclusion than was offered at trial. So that's the influence, right? So that's influence that's not racial bias. That's how the human mind works, right? Is that we tend to take in information that confirms what we already believe, right? That's why, the internet echo chamber is so dangerous, right? So if you believe that, his election was stolen, right? There's a whole universe of confirmation feedback that you can get that will, validate that opinion of yours. That's true with everything in our lives. That's the way the human mind works. So in forensics, it can be very, very deadly. It also, racial bias plays a really significant role in this as well, right? If you think about that same expert, Dr. E.T.L. George, did another study in forensic pathology recently. And what it showed, to be very reductive and simplistic about an otherwise, the study, but basically what it showed was that black babies come into the emergency room with the same injuries that white babies come into the emergency room. The black babies' caretakers get charged with homicides, and the white babies' caretakers go home, right? So the conclusions about whether or not this was abuse or an accidental injury is influenced by things like irrelevant things like race. And still we have no efforts to shield experts from that type of information. It's very hard when you're talking about an actual person, right? You can't shield that information from somebody's eyes. But it gives you another example of just how dangerous the influence of bias that has nothing to do with actually a valid scientific opinion is to leaking into these opinions. So all this to say is that this is what I mean by junk science, right? There isn't valid empirical research that's underlying it. It doesn't have valid error rates, and it's subjective, and it allows in biasing information. So one of the reasons that this is such a powerful prosecution tool primarily is because the prosecution doesn't make any effort to shield their experts, which are the experts who are typically testifying at trials, from this type of information, right? So the experts are very likely to confirm the prosecution's theory. So this is very problematic, especially when you have innocent people on trial, and evidence that can be made to sound like scientific evidence and make them look very guilty is in fact wrong. So part of the reason that I wrote this book is to try to change the narrative around the infallibility of forensic sciences that have been built up in the post-World War II era, beginning with shows like CSI, or like Quincy, back in the day, right? So there's that's the forensic pathologists that are doing manner and cause of death, right? So I talk about cause of death. That's something that a doctor really, might have something to say about. Manner of death is like this investigation stuff, right? Was it a homicide or was it a suicide? And there isn't any training for that. There's no reason that a forensic pathologist should necessarily be doing that, and they don't do that in other countries, but they do it here. So how did this happen? How do we get to this spot in this country where junk science is so prevalent? So I want to say something, and I'll emphasize it now, and I'll probably say it again, is that of all the wrongful convictions overturned through the use of DNA evidence, nearly half, actually I think it's now more than half, involve the misuse or the faulty forensic sciences. Half. And yet we still have a long way to go for reform. So let's just go back to how we got to where we are today and how we even know this. Is that being a forensic scientist, right, that wasn't a profession before World War II. You couldn't like grow up in, the kids weren't in the 40s growing up saying, I want to be a forensic scientist when I grew up. That wasn't really a thing. It was only in the post-World War II era that two forces really came into being that created an entire industry of expert witnesses and forensic scientists. And on the civil side, it was the explosion of personal injury litigation, toxic tort litigation, product liability, the whole industry of plaintiffs' attorneys that sprouted up. And these attorneys were getting very wealthy by suing corporations, right? Corporations like Ford Pintos are taken off the road, that was a good thing. But a lot of it was bogus, right? So a lot of corporations were being sued by, and effectively plaintiffs' attorneys were effectively using suspect evidence by expert witnesses. And the industry got so large that it created a cottage industry of expert witnesses. These are people that worked in fields, but they didn't actually work in the field any longer. Their whole job was to testify as an expert witness. That was insane. So you could become a professional expert witness. That wasn't true before the 1970s. Board certifying entities sprung up, right? So they were essentially clubs that sometimes they would test the abilities of these experts, of their claimed abilities. Sometimes they wouldn't. Sometimes about paying dues. Sometimes, then you're board certified. So it became an organized profession. And on the criminal side, what we had was the explosion of mass incarceration, driven by the Anti-Terrorism and Effective Death Penalty Act, which was passed by Bill Clinton's administration, a lot of racist rhetoric about super predators and then cut off all these avenues of relief in federal court to look at state court convictions. And of course, the drug war. These two things ended up with 2.3 million people in various forms of incarceration in the United States today. So we have on that side and on the civil side more and more scientific evidence being used in criminal trials. And on the forensic side, the first to organize themselves into a body was the forensic pathologist. They had a board name, and another organization started offering board certification to forensic pathologists. This was going on in the 80s, and suddenly forensic scientists became a thing. The FBI crime lab opened, state crime laboratories began to open, city crime laboratories began to open, DNA, like a little bit later, came online. People became professional trace evidence experts, like fingerprints and shoe prints, and you call them, or you'd heard of them called ballistics, but it's really firearms and tool mark evidence. All this became a profession that you could aspire to. And then one of the real sheltering principles, though, is that with forensics, there isn't any application for most of the expertise outside of criminal courts, right? You don't need a ballistics expert in your everyday life. You don't need to match fingerprints at crime scenes, right? So it became very, very specialized and not really subjected to mainstream scientific scrutiny. As a result, kind of best practices got built up through local crime labs and police that would go to trainings that were done by, either experts or crime labs. And what we saw increasingly is the use of junk science. And what we didn't know at that time was how many wrongful convictions were being accumulated through the use of these techniques that were being passed off as scientific evidence. So I wanted to use the bite mark people, the forensic odontologists, as an example. Forensic odontologist is just a fancy word for forensic dentist, and odontologist is what they call themselves when they're in court to impress jurors. That's really the only reason. And they were working in the medical examiner's offices alongside the forensic pathologists the whole time, right? You all heard about bodies being burned beyond recognition, right? And that they're only identified through their dental records. But what you probably didn't know is who's doing that, right? It's your friendly neighborhood forensic odontologist, and they are the ones that are using dental records to identify dead bodies, and they've been doing that for centuries. But they weren't in the expert witness game. They weren't part of law enforcement. They weren't solving crimes. They weren't testifying as expert witnesses. They weren't making that money, and they weren't getting that kind of exciting career opportunities that a lot of people who go into forensics view that as, right? They weren't testifying. They weren't part of a law enforcement apparatus, which is one of the real problems with forensic sciences, is that so many of the experts in this field view themselves as part of law enforcement, as crime solvers, right? Not scientists, right? That are just coming to a conclusion, whether it helps one side or the other, as they should. And this is particularly problematic because we talked about the subjectivity. The dentists were part of this world, but they weren't getting into court. And so what they did, and I filed a lawsuit to get into the archives of these people, and was able to actually find the source materials. And I read it all, so you didn't have to. So it's in the book. But what this shows is that they started pointing to bite marks as a potential identification tool, right? So the idea is that, well, we're seeing what we think are bite marks, and you can never know because you weren't there, and a lot of injuries that look like they might be bite marks were not, as the evidence in some of the cases I talk about in the book show. But they were saying that if we found the teeth that made these marks, then we'd have the bad guy, right? So like all junk science, it has superficial appeal, right? Makes some sense. If we match this bite mark up to the teeth that made it, then we have the perpetrator, right? So if you're not critically thinking about it, then it does make sense, right? Bloodletting, that's a practice that went on for thousands of years, right? It made some intuitive sense. I'm sick, I changed my blood, I feel better, right? Why not, right? And so that worked, obviously it was nonsense, but it lasted a long time because it had this kind of intuitive appeal. Same was true with bite marks. So I'll just say one thing. You'll have to kind of take my word for it that bite marks are junk, but one thing that I'll point out to you that maybe this will be enough to persuade, or you'll have to read another chapter of my book. But the idea is that, and I never saw this cross-examination. Every time I was looking for cases like Stephen Chaney's and reading these transcripts, I never saw this one couple of questions that should have blown up the field, right? So you would get these dead bodies that are photographed in a mortuary or the medical examiner's office or where have you, and a bite mark is discovered, right? This is often days, sometimes weeks after a homicide, or days, sometimes hours after a living victim has been assaulted. A living victim might be able to say, so-and-so bit me, or this was a bite mark, and that would eliminate the need to diagnose it as a particular bite mark. Putting that aside, is that skin, particularly a decomposing skin, changes minute to minute, hour to hour, day to day, right? So it looks nothing like when it was first imposed. This injury changes all the time, right? So you might match one day and not match the next day, right? So whether it matched it when this particular doctor or this dentist took a look at it without any measurements or just eyeballing it is nonsense, right? Because maybe he looks at it the next day and there's no match. But I never saw that cross-examination, and they got away with it. And they did it in the same way that, and they're still doing it today, is that you can get hoodwinked into not critically thinking about the claimed expertise, right? And so what they did is that the founding fathers of this field, of forensic odontologists, the American Board of Forensic Odontology's founding fathers, right? This is a club that was invented without testing any of the credentials or the expertise. What they would do is that they would go to court, the first case, and then several other cases that passed, and essentially make the argument that, well, we identify people through their teeth, and we also identify people through the bite marks their teeth create, right? So that sounds like kind of opposite sides of the same coin, right? So, but I don't know what it would be about being a dentist that would make you an expert in bites and bite marks on skin, right? The proximity to teeth, right? That's nonsense, right? Just like you're no more expert than you or I were. But that worked. But to quote a line from my book, I say it's more like a geologist claiming because she can identify a rock that she can identify the rock that was used to bash in somebody's head, right? These are different things entirely, totally unrelated, but they worked. So these dentists got this in the court the first time. And you can see this force in all times of forensic techniques. The way that it gets into court to begin with. It's really important to have a good test case, the right type of evidence. The first case that was used did not involve human skin, involved cartilage in a nose. So forgive the graphic nature of this injury. I'm going to explain it very quickly. But this poor woman's nose was bitten off, essentially. But that's an injury that's in cartilage. Doesn't change the same way that we talked about than the human skin does, right? And so you could kind of eyeball this match. And it was a bench trial, it wasn't a jury trial. And the judge took it as relevant, and it shouldn't be relevant, but the judge did, that the defendant spent 6 weeks in jail rather than voluntarily give up a mold of his teeth to match it to this injury on the nose. So the judge decided, the judge acknowledged out loud, said, I recognize that there is no scientific research to support this, that there hasn't been any orderly experimentation was the word that he used. But this stuff is so simplistic and so basic that it's not going to mislead or confuse a jury. The jury can see for themselves whether or not that there's a match or there isn't a match, and so I'm going to admit this evidence. The evidence gets in. And then it spreads like a virus through the criminal legal system. And you can see it, and I mapped it. This is for a law review article, a very boring law review article that I won't suggest to you, but that I mapped it through the criminal legal system. You could see precedent-establishing cases across the country that all relied on this initial case. None of them interrogated the evidence that any of the scientific research that was used to support this, just cited to this case law and admitted bite mark evidence. And then the next thing happened, and this has happened in a number of industries, in a number of fields, is that you get a very high-profile case. Ted Bundy, right? So how many of you are aware that Ted Bundy was convicted on bite mark evidence? No kidding. That's shocking to me. Well, I'm going to tell a story anyway, because I think I'm going to tell it like a little bit different. Is that because here's some other research that I did, so you didn't have to. I read every single article that was written about Ted Bundy from the time that the body started disappearing in Seattle till the arrest in the Chi Omega murders. And what was amazing was that there was really never any evidence against him. That one person who'd gotten away who gave very generic description of Ted Bundy, and then they never had hair, they never had fingerprints, they never had another eyewitness, they had nothing. When they finally stumbled onto this arrest in Tallahassee, they had the sheriff outside who gave a press conference when Bundy was first arrested. Everybody in the world believes he's guilty. I'm not here to argue that he was innocent. But what they didn't have was any actual evidence. And he admits this during the press conference. He says, it's his MO. We know he was in the area. Seems like it's probably him. Problem is we don't have any physical evidence. And they're searching for it. And he says something, he's like, well, somebody said something about a bite mark, but that was very faint, and that's not great evidence anyway. I don't think we're going to do anything with that. And so he spends the next 4 months searching for evidence to indict Ted Bundy for the Chi Omega murders. And they're screaming headlines day after day that, when is he going to bring this indictment? What's going on with Bundy? And Bundy is like his antics because he's acting pro se and causing a lot of media sensation. The media narrative starts to shift away from the victims towards this fascinating serial killer. They can't believe somebody so handsome, and so well-spoken would be a maniac killer, right? So that became the story. So more and more pressure falling on the sheriff to find some evidence to bring this conviction. And this is the same kind of forces that often lead to wrongful conviction, right? I talk about those in my book. Again, I'm not here to argue that Ted Bundy is innocent, but these are the same types of pressures that often lead to wrongful conviction. Because what happens after about 4 months is that this faint, useless evidence becomes Bundy's signature that he left on the victims, and the case ends up rising and falling on bite mark evidence. It was the first case in Florida to use bite marks. It also cited this first case back in the very first original case of bite mark evidence, except for now they're calling it scientific evidence, and Bundy gets convicted. And what really became how many more victims Ted Bundy actually really had, if you consider them in terms of wrongful convictions around bite mark evidence, at least 35 more victims that were wrongfully convicted, because bite marks became mainstream part of popular culture because the dentists were the stars of that trial. And it was the first nationally televised trial in our country's history. And Ted Bundy himself was cross-examining the dentist, right? So we have junk scientists being cross-examined by a madman, right? That's made for television, right? And so that's what happened. So bite marks became this new phenomenon. And you could see them when I was searching for these cases. They would prop up in geographic areas, right? They were like cancer clusters. It's like, what's going on? And what you could see was that you would get a newly board-certified forensic dentist in a particular area, and suddenly you're having lots of bite mark cases, right? And I pointed this out once to I sometimes end up having to spend time with some of these dentists, so you can imagine I'm not very popular with that crowd. But what they'll say is that, well, they were just missing that evidence, right? They needed us, to come along, so they were missing all this useful evidence, But what happened in 2015 is they did a study that showed that the dentist could not reliably diagnose a bite mark, period, right? In other words, the injuries that you have in your mind's eye of a bite mark, right, is probably something like any of you have toddlers, they come home from daycare and they have a bite mark. It's a Johnny bit me, right? And it looks like a bite mark. That's not what what they look like in casework at all. Never, right? And so there are some pictures that are in the book that will show you what the injuries look like in actual casework. So, but that again, that was never tested. And they became a mainstream scientific evidence and started cropping up in all these different areas. And when I was first taking a look at these, you could see that this industry had been built on this house of cards, but they had textbooks, they had board certification, they had these incredible credentials that made it sound like they really knew what they were talking about. And it was really astonishing to me, as kind of a newbie in the field, that you could have so much, I don't know, I was going to call it data, but I don't think that's right, that you could pile bullshit that high, right? It was just like textbooks and articles and all these other things that all was supporting nothing. Total junk. And how do we know this? Right? It's not just because there's no research. It's because of the wrongful convictions. And none of this was thought to be possible before the advent of forensic DNA analysis and the Innocence Project. It was, up until that time, jury verdicts were thought to be essentially infallible. Notable exceptions have been, raised in history that we're all familiar with, but basically, jury verdicts were correct. You get your one appeal if they did something wrong at trial, and then that was it. And there was something called the principle of finality that is a really important legal doctrine that really, the idea behind this is that once a jury has spoken, that the victims are entitled to finality, the system is entitled to finality, we have to move on, and you're entitled to a fair trial, and really that's it. And the idea that somebody innocent would be convicted or sent to death row was really not, it was very disputed, it was debated, but it wasn't really a thing. And we had the advent of DNA, forensic DNA. And there's a big difference between when I say forensic DNA and regular DNA. It's really, really important point to make, because DNA existed, but then moving it from a pristine lab into a messy crime scene evidence is a little bit like when we were talking about latent fingerprint evidence before, is that you can draw blood and do a DNA test in a laboratory, and it's one thing. And then finding a smear at a crime scene and testing that might have 3 or 4 different contributors to that DNA is totally different. But in any event, it comes and gone. And what was really important, 1992, this is our 30th anniversary year, what I think was really brilliant, and this wasn't me, I wasn't there yet, was the intake criteria of the Innocence Project. And what was really important, and it really just shows, how problematic our subjective opinions can be, is that they decided that they were going to make no subjective judgments about the guilt or innocence of people that were going to be writing to us for our help. In other words, they weren't going to look at the quantum of evidence and say this guy is obviously guilty, we're not going to take this case. What they said was, if biological evidence can be found, if DNA evidence can be found, and it's been collected and stored in some way, and if we could test it, if that would prove innocence, we would take the case. So it didn't matter. Nothing else mattered. Just if you could come up with a theory that our intake department would come up with, right? Say, well, we think if we found DNA on this bandana, it would show who the actual perpetrator is. Okay, we'll take that case. And what that showed was that all of the most fundamental parts, the fundamental elements that were used for typical criminal convictions, eyewitness identification, forensic sciences, confession evidence, was all highly unreliable. We had cases where 6 eyewitnesses were identifying our clients that were totally innocent. We had clients that had confessed to capital murder, had apologized to victims and given detailed statements in their confessions. They were innocent, right? And then we have forensics, thought to be, since the World War II era, the FBI crime lab was lionized around the country as infallible crime-solving G-men with microscopes, right? More junk science is coming out of the FBI crime lab than any other crime lab in the world. Compared to bullet lead analysis, voice spectrometry, hair microscopy, all originated at the FBI crime lab. All junk. So the Innocence Project becomes a paradigm-shifting program project in the country and now around the world, because it demonstrated the fallibility of our jury system in this country. It also exposed the inherent racism that underlies, we didn't need the Innocence Project for this, but I guess it contributed to that in the sense that nearly half of our exonerees are people of color, and that's a great overrepresentation as the population at whole. So what are we doing now? Now that we know this, right? Now that we have all these data, we have 30 years of exonerations, and we have 2 reports, 3 really, but 2 major reports, because what happened is that mainstream science had never looked at forensics, right? So talked a little bit about how this bubble grew up, right? And a lot of the forensic techniques that are being taught are not being taught in institutions like Hofstra. They're being taught by guild-like structures, right? So these are board certifying entities, or some sort of like the Association of Firearms and Tool Mark Examiners, these types of things. And what's an apprenticeship program, much like a carpenter or any other type of guild. And what you have is a mentor that's going to give you all of your instruction, tell you what literature to read, what to believe, what not to believe, give you all your casework, all your publishing opportunities. And that just wisdom, for better or for worse, gets passed down from generation to generation, right? So that's what happened in medicine. That's why bloodletting lasted so long, right? And we didn't have evidence-based medicine until the 80s, right? And there's the same kind of subjective beliefs that were underlying most of the field of medicine. A lot of it was valid stuff, but a lot of it was nonsense too. And there was something called the Corcoran Report that was similar to the report I'm just about to talk about in forensics, that was done by non-doctors that pointed out that the lack of a statistical foundation for a lot of the claims that were being made by medical doctors. In forensics, as a result of the work of the Innocence Project and similar organizations, mainstream scientists and the public became more aware of the problems of forensic sciences. And so what happened is the National Academy of Sciences, which is the most significant scientific organization in this country, if not the world, Congress commissioned them to do a study on forensics in 2006, and they produced a report in 2009. I write about the hearings because they were very contentious, and forensic experts who had never really been questioned at all about their expertise were suddenly under fire by mainstream scientists, serious skeptical scientists. They're supposed to be skeptical. That's what science is about, right? Is challenging your hypotheses, trying to falsify them. That's how they get better. So this report comes out, and I called it the 38 world words that changed the world, something like that. And what it is, and this is a long report, but fundamentally, what the takeaway was, and let me just back up, like for individualization, if you talk about a gun case, right, you've all heard about that gun fired that bullet to the exclusion of every other gun, every manufacturer in the history of time, right? There was a ballistics match, right? You hear that on television all the time. There's no empirical basis to make the claim to individualization that that gun being the only gun that could have shot that bullet. They say that about tire treads, they say that about shoe prints, they say it about firearms, they say it about knife marks on the sides of windows, whatever. That's called individualization. So when the National Academy of Sciences came out with their report in 2009, they said only DNA analysis of all the forensic techniques that they had looked at, only DNA analysis was capable of identifying the suspect at a crime scene. And even DNA, you get a likelihood ratio. You don't get it's like that's the only one in the world because we haven't tested everybody's DNA. But they have a sufficiently robust database of DNA that they can make the claims that you hear in court. Like I saw 1 in quadrillion chance it would be somebody else. But they make similar claims called individualization and all these other techniques. And the NES was the first report that pointed this out. Much like the Brandon Mayfield scandal, this was a shockwave across the bow. People were outraged in the forensic community by this. And similar to the way the doctors responded to the Corcoran report, it's like, who are these statisticians who have never been to a crime lab, never been to a crime scene, telling us our business, right? And so while at first there was a lot of like hand-wringing and people were very worried and we're not going to be able to testify as experts anymore, and then the political backlash began. And what you see, and there was reference to some of the responses to the pandemic that are kind of similar, and this is a line that I read in the Times, which I think is a good line because it's true, is that when you mix science and politics, what you get is politics, right? And this is what we're getting with forensics now, is it's a very politicized debate, right? If you're a very pro-law enforcement person, or a prosecutor, or a crime scene expert of some sort, you're up down there or out there maybe right now is that Fabricant's full of shit, right? Everything that I say is wrong, right? And then if you're, a defense attorney, or you're just like kind of, here and you didn't have an opinion, then I'm probably fairly persuasive. I'm with the mainstream scientists, right? But there are lots of people who disagree with this, with everything that I've said. Because, in my view, people make their livings doing something. And if you make your living and your job is about putting people in prison and in death row, and you've been declared an expert witness from coast to coast, it's very, very hard to walk that back and to question your own previously held beliefs. It's just not the way that most humans work. And junk science pervades as a result. In the civil side, we talked about all these corporations getting sued. A lot of it was based on junk science. And corporations were getting tired of it. Obviously, criminal defendants were getting tired of it too, but they don't have the same juice that corporations do. And what they did was tee up a case to the United States Supreme Court called Daubert. It looks like it should be called Daubert, but I know people who know the Dauberts. That's the way they pronounce the name. So they were people that alleged that they had taken a pregnancy pill that was supposed to deal with morning sickness called Benetton. And the allegations were that this drug caused birth defects. And so they brought a lawsuit that was based on plaintiff's expert witnesses and brought it to the Supreme Court. And what the corporate defense bar wanted was a new paradigm for the way that expert witness is going to be, or the way that expertise or expert witnesses or scientific evidence is going to be used. It used to be something called the Fry standard. And what that was if a technique is generally accepted in the relevant scientific community, that evidence is going to come in. So it's essentially a nose counting exercise, right? So we're going to define this community, and if that community believes that this is good stuff, then it's going to come in, right? So we're judges, we're not scientists, we're not going to make that judgment. We're going to defer to the relevant scientific community. The problem with that standard was, and is, New York is still a Fry state, is that when we talked about how high you could pile, all the nonsense to make it look like, a valid profession or a valid science, you own that science, right? So courts are defining the relevant scientific community as the proponents of the technique themselves, those whose livelihoods depended on the continued acceptance of that technique in court. So the answer to the question of whether or not it's generally accepted by the people whose livelihoods depends on it, the answer is obvious, right? So what they did in Daubert was say, okay, the corporate defense bar wins. We're changing this paradigm, and the courts are now going to act as gatekeepers. And what that meant was that they were going to have to apply basic scientific principles before they allowed scientific evidence to be introduced at trials. They'd have to look at things like error rates and peer review and testability, things like basic measures of science before they would introduce that. And it worked. In civil litigation, a 40% increase in the study that was done about 10 years after the Daubert decision showed about a 40% increase in exclusions of expert witness testimony in civil trials. In criminal trials, despite everything we've been talking about with DNA exonerations and half of them being attributable, at least in part, to faulty forensics, nothing changed. Prosecutors still got in whatever they wanted. Defense attorneys were never successful in challenging them, despite all of the evidence in the NAS report, of the wrongful convictions that we knew were leading to wrongful convictions. This is like I developed a theme in the book called this poor people science. And the reason is that we have all of this evidence of the fallibility of forensics. We have people in prison and death row right now, right today. I have 3 clients in death row that are all there just on bite mark evidence. Is that we don't care about the evidence that's used to condemn poor people, particularly poor people of color who are overrepresented in our criminal legal system. And it shows because when money is at issue, we're much more likely to get it right. When life and liberty of poor people are at issue, we don't care. We don't take those tools out of the prosecution's tool belt, despite all the evidence of its infallibility, or fallibility, I should say. So I often would end right there, because that's such a downer. But I'll say that, and I'll give away a little bit of the book, is that Stephen Chaney is ultimately freed. And what it took, and this is the direction that I hope that we're going, the different elements that it took, and I explore the Dallas District Attorney, the history of the Dallas District Attorney's Office a lot in the book, because Stephen Chaney's case comes from that, and really everything that you need to know about the criminal justice system you can learn through studying the history of the Dallas District Attorney's Office, particularly beginning with Henry Wade. Henry Wade, who's the Wade in Roe v. Wade, was responsible for at least 20 plus wrongful convictions. His head of the homicide bureau in Dallas was a Klansman, and they worked hand in hand together for nearly 40 years. And what's remarkable and paradoxical about Dallas, though, is that same office elected the first black man in Texas to be head of a DA's office. It started the first conviction integrity unit. In other words, this was, how many of you heard of conviction integrity units? Right? These are a few. So these are a new thing, right? Relatively new. Craig Watkins in Dallas is the first. And that had never happened before. We had district attorneys that were examining their own convictions and overturning them if they found that they had been wrongful convictions, right? That had never happened before Craig Watkins and the advent of DNA, showing that this was a real thing. So that happened in Dallas too. And you heard me reference the junk science writ. That was the first law in the country that allowed prisoners to go back into court and argue that they've been wrongfully convicted if they can demonstrate that the science that was used to convict them had been discredited through the passage of time. And then we had the Texas Forensic Science Commission in Texas as well. This all relates to Chaney's ultimate freedom. And the Forensic Science Commission, which had been shut down by Governor Perry, Rick Perry, the guy who ran for president and who was Secretary of Energy, right, as and a global climate denier, but nonetheless, that was his job. And he had signed off on the execution of Cameron Todd Willingham, who was an innocent man, who was executed for murdering his 3 daughters through setting his house on fire. It was all based on junk science. I explore it a lot in my book. The Forensic Science Commission was going to issue a report around that case. Governor Perry fired the commission right on the eve of the election, rolled to re-election, neutered the commission. We filed, when it got back up and running again years later, on Chaney's behalf around bite mark evidence to see if they would issue a report. So we had all these forces that came together in Dallas, that we had a conviction integrity unit, we had the NAS report, we had the junk science writ in Texas, we had a new forensic science commission that was ready to take a look at it. And for the first time, and I write this scene in the book where I was entering, usually what you would do with a conviction integrity person is, let's test this DNA, let's see if we can establish innocence, is that we knew that there wasn't any more DNA to test. And what we had to do was go in there and argue that he'd been convicted on junk science. So it was persuading a prosecutor that they had used junk science to convict our client. And it worked. She agreed. Susan Hawk was the DA at the time. And so then, citing the NAS report, a Forensic Science Commission report, using the junk science writ, and then it went to the Texas Court of Criminal Appeals and they signed off on it. So that's progress, right? Is that if we can do that, if we can show that all this evidence that was once believed to be infallible is actually convicted an innocent person, and we can do it without DNA evidence, it gives me hope for my clients that are on death row. It gives me hope for the future, that if we can demonstrate that people are currently incarcerated on techniques that are still being used today, that they won't be used anymore. So I'll end by saying what we need, rather than all the true crime that we have and all the true crime episodes and all the rest. I have clients that were on Forensic Files. Look up Alfred Swinton. Google Alfred Swinton. He was on Forensic Files. They said he was a serial killer, right? He was innocent. I saw that show. I was like, he seems innocent. And we took his case and he was exonerated 18 months later. True story. So what we need is untrue crime, not true crime genre. And that's what I'm here to proselytize about. thank you so much for having me. I'll take questions. Yeah. Oh, yeah.
Yeah, how you doing?
Good, how are you?
My name is Henry I. Cisco. I'm into the legal field. I'll just leave it at that. I just want to ask you a question. Are you familiar with this individual, Lemuel Smith?
Yes, I'm familiar with Lemuel Smith.
Exactly.
I can tell you a little bit about Lemuel Smith and his case. This is one of the craziest bite mark cases that I've come across. I should be familiar with all of them. And I can tell a little bit about Lemuel Smith if that's all you want. So Lemuel Smith was probably appropriately convicted of a couple of homicides, but then he was incarcerated, and a prison guard was murdered. I think it was in Sing Sing, but it was Greenhaven. Okay, it was in Greenhaven. A woman, and they found her body outside of the prison. So it's very mysterious how she'd been murdered. Lemuel Smith falls under suspicion. I don't remember all the details as to why. But they didn't really have any evidence except for what they thought was a bite mark on it. And so there was an expert witness here in New York named Lowell Levine who had testified in a prior trial that Lemuel Smith had been convicted of a homicide. And he said, and remember what I said about how bite marks appear, like day to day, right? He said that he recognized the bite mark on this new victim from the work of this prior case, the victim, right? So that was the telltale bite mark that he could tell that it was Lemuel Smith just by looking at it, and they recognized it. Lemuel Smith, I think, is still in solitary confinement for something like 25 years and really suffering, I'm sure, in upstate New York. And that case is the New York Court of Appeals case that still stands for the proposition today that bite mark evidence is good stuff. And this is the problem with so much of the junk science, is that when judges are considering whether or not they're going to introduce scientific evidence, they're not consulting the literature, right? What do you think they're consulting? Case law, right? And case law, as we see, bite marks are still good stuff in case law. Other questions?
Hi.
Hi.
My name's Sarah. I'm a criminology and public policy student here.
I hope I haven't offended you.
No, not at all. New York State doesn't have any laws concerning preservation of evidence, and I wanted to know what the Innocence Project is doing about that and how that affects the cases that you're working on.
The Innocence Project has tirelessly advocated for preservation of biological evidence, and there are laws in most states now that are requiring district attorneys and police departments to preserve evidence. And there's a terrible case called Youngblood in the Supreme Court that found that there is no due process violation for destroying or losing evidence post-conviction, right? So you could have evidence of your innocence sitting in some closet somewhere that somebody throws away, and there's no due process violation. Nothing you can really do about it. It's just very unbelievable. Yes, sir.
Hi, my name's Nate. I'm a public policy major, and I just, in the beginning of your seminar, I just had a question in regards to some of the things you said. If I'm getting it right, I was just trying to summarize it. So there was essentially a market after World War II for, things around forensic science, and essentially, the building up of that created and, supplemented to, essentially our mass incarceration rates.
Yeah.
Is that okay?
Yeah, it was just something that didn't exist before, and the way that I've argued it in the book is this is another tool to maintain the status quo, and that's why it's been so hard to rid the courts of it. But there wasn't an industry, there wasn't really the need for it, because before that era, it was mostly eyewitness identification, confession evidence, circumstantial evidence, that kind of thing. It wasn't so-called trace evidence. Was there somebody over here? I don't mind if you don't go to the mic, but I think they.
Just speak loudly.
She's saying that you need to go to the mic. Yeah.
My name is Emma Behrens, and I'm here with Professor Burke's criminal procedure class here at the law school. And I actually wrote down my questions so I don't mess it up. Do you believe that the heavy need for exonerations in the aftermath of junk science will dissolve in the rise of newer technologies such as surveillance footage, phone records, Ring doorbell footage?
So emerging technology is, I don't think it will replace traditional forensics. It's going to supplement it. What my chief concern, well, I have a number of concerns around emerging tech and surveillance technology, is that increasingly private corporations are getting into the business of forensics, right? And they're doing this not to advance justice necessarily, but to make money. Nothing wrong with making money, but it's deeply problematic in the criminal justice system where we're really deciding life and liberty issues. And we in strategic litigation do a lot of litigation around this issue as it relates to black boxes that are being, that are more and more. It's not a forensic expert that's on the stand that's accusing your client of a crime. It's a black box. It's a computer algorithm. It's source code that has come to some conclusion. Often technicians don't even really understand it. They put in the data, they get a result. And what defense attorneys need is to be able to cross-examine. Their Sixth Amendment right to cross-examine and confront the witnesses against you, which is increasingly a computer. And what we have with private companies is an unwillingness to turn over source code to defense experts to interrogate the basis of the opinions. And I thought that this was going to be relatively straightforward litigation, that we were going to win these cases, and that, obviously, it's a fundamental right confrontation. But we've had many courts elevating trade secrets and proprietary rights of corporations above fundamental rights to confront witnesses against you. So this is a battle that's ongoing. So that's my chief concern, because there's a lot of incentive by corporations to hype the technology beyond its capabilities, and a lot of incentives by judges and jurors and prosecutors to buy into the hype. So that's my depressing answer. Sorry.
Hi,
Hi.
I'm Nicole, and I'm a law student too, and I'm
Good.
going to be a prosecutor next fall.
I'm sure you'll be a righteous one.
Yeah, so I guess I'm kind of just wondering, after listening to this presentation, what kind of advice you would offer for someone in my position who is about to be a prosecutor, with an eye to the fact that, some of this forensic tech and some of this forensic evidence might not be as accurate as I thought it was before you speaking.
Thank you for your question, and and I don't mean to hassle your field so much, but two things. One is you have to be skeptical, right? Is that just because somebody in a lab coat says something, that this technique is capable of doing X, Y, and Z, ask them about the critique that's available in the NAS report and something called the PCAST report, and see how they respond to that. And the other thing is blind your experts, right? Your experts don't need all that irrelevant information. Just blind the experts. And I'll be interested to hear whether or not that they will agree to that, because many of them are very resistant to that. But if you want an objective opinion, something that is this going to be a relevant fact, or is this just going to confirm my theory, then you'll blind the experts, right? And I'll tell you what I do is that when I blind my own experts, and I feel like sometimes I put them at a disadvantage as a result, right? Are my clients being disadvantaged because I have accepted the science of cognitive bias, and therefore I don't want a biased opinion? I don't know. I grapple with that, but I blind them anyway. And then when I'm cross-examining the states, your experts, right? I'm saying you knew all this information, right, before you came to this technique, to this conclusion. All this subjective information that had nothing to do with your analysis. We know what happens when that. We have the ETL Juror studies and all these wrongful convictions to demonstrate that. And then when I'm eliciting from my expert, it's like, you knew nothing about this case, right? I told you nothing, gave you no facts. You didn't know if I wanted it to match, didn't want it to match, and I found that to be pretty effective. So that's my advice.
I would have a hard time coming back from that. Thank you.
I'm happy to sign books for those of you who are going to get them if there's no more questions.